The broadcast is now starting. All attendees are in listen-only mode.
Hello everyone, welcome to today's presentation. My name is Frank Gilman, Chief Information Officer for Lewis Brisbois, and it's my pleasure to host today's webinar on Ediscovery Cost-Containment Strategies. It's brought to you as part of our firm's SEEDS initiative, an informational program focused on both cost-effective and cutting-edge e-discovery solutions. This session is eligible for 1 hour of CLE credit, and we're glad you've taken the time to join us. A couple of quick housekeeping notes before we begin. Today's session is being recorded, so if you want to revisit any part of the presentation or forward it to a colleague, we'll send you a link to the presentation in about a week. For best sound quality, we recommend using the telephone option instead of your computer's microphone and speakers. To do so, first select the telephone radio button located in the audio section of your control panel. When you select telephone, a dial-in number will appear along with an access code and an audio pin. Our panelists welcome your participation, but they cannot audibly hear you. All phone lines have been muted and will remain muted until the question and answer period toward the end of this event. We do encourage participation, so at any time you may type a question in the chat window at the bottom of your control panel. I think one of the things lawyers and claim professionals alike struggle with are the potential costs of e-discovery. They're scared about how high the ultimate ceiling might be in terms of price, but the truth is, done correctly, the cost of e-discovery done right is absolutely the most cost-effective solution for handling large and even smaller amounts of electronic data. To tell you how to do it and give you some best practice tips, I'm honored to introduce our panelists for today's presentation. Gordon Calhoun, the chair of Lewis Brisbois' e-discovery information management and compliance practice. Robert Milburn, legal solutions executive for Canon Business Process Services. And Brad Perry, electronic discovery and litigation support executive, also with Canon Business Process Services. Rounding out our group is Kevin Neal, a fellow in corporate communications with Canon, who's going to go over today's agenda. Kevin? Ken?
Yes. Good morning, everybody, and in some cases, good afternoon. This is our agenda for today. We're really going to be covering two key topics. One is an e-discovery costing primer, and we'll touch on information governance costs and some traditional e-discovery cost categories. And the second topic is really our core subject for today, e-discovery cost containment strategies, and we'll be touching on 4 of them, including information governance investments, pricing models, analytics, and technology partner management strategies. And we'll end our session today with a Q&A. But first, if we go to the next, we'd like to get started by asking you to participate in a brief poll question. And the poll question is showing on your screen: which of the following best reflects your past experience with e-discovery? A, I am an e-discovery pro. B, I have managed e-discovery personally. C, I know about e-discovery and want to learn more about it. And D, what is e-discovery? So if you could just take a moment to answer the question, we will have your results and probably want to comment on them in just a few minutes, or a few seconds, actually. Okay, here are some of our results from the poll. Do any of our panelists have any comments or see any surprises here?
No, Ken. Thanks. This is Brad, and I think that this will help kind of shape the direction of where we go today. I'm glad that we've got a number of people on the call that know a little bit about e-discovery and want to learn more about it. So the topics today will be very useful for those people. So why don't we go ahead and get started and start talking about some of the e-discovery cost categories and the costing primer. To start with, as Frank mentioned, and that cost containment of electronic discovery is, it's a challenging topic, and it implies, I think, both reducing costs and making costs, more predictable. It's a priority for corporations, because data volumes continue to rise, and our economic conditions continue to apply pressure on legal department budgets. And then, law firms, they're going to feel pressure because their clients are obviously demanding more for less. And, so outside counsel are probably being asked to, rein in the costs and provide visibility into the costs throughout the entire discovery process and just generally deliver a higher value, which is something that, Lewis has put together with their SEEDS program that provides a much higher value and visibility into the whole e-discovery cost throughout the discovery process. So in general, I think that we can categorize the costs of e-discovery into a couple categories. On one hand, you can look at it like you've got the costs of potential sanctions, lost opportunity, and soft and hard costs. And, those cost components, they'll probably overlap into some of those general buckets, but I think those are good general definitions. And, soft costs can range from the efforts that you spend preparing for litigation, creating a record management program, litigation hold policies, managing your technology infrastructures, those types of things. Those are your soft costs. And, your hard costs are going to be distinguished by, more definable things that are inherent to electronic discovery with sort of high ticket value associated with them, like collecting your electronic data and the actual review and those types of things. So I think that there are, generally also two categories of budgets. We've got, budgets that are made by the corporation for information governance to help plan for discovery response later on. And then we've got budgets that are related to the specific case that is at hand, and that has to deal with the processing, review, and production of the electronic documents. And that's what we're going to kind of focus on today primarily, and talk about some of the strategies to reduce your costs. I'll just end that by saying, a cost containment strategy starts, a good strategy starts with collaborating with your corporate counsel and your litigation support staff, outside legal counsel, and of course e-discovery experts, so they can provide guidance regarding cost considerations and estimated guidelines. And yeah, so like I said, today we're going to just kind of focus on the case budgeting. So Robert, can you kind of tell us a little bit more about the size of the cost of discovery, and where does most of that cost kind of lie?
Yes, thank you, Brad. Advanced slide, please. Frank, can we advance slide?
Yeah, I'm doing that.
Okay.
Do you not see it, Robert?
I'm not advanced, but I'll jump in. Okay, so in terms of attorney or e-discovery costs, there was a RAND study in 2012 on e-discovery costs that went to looked at a number of different e-discovery cases and found that of a large portion of e-discovery cases, out of 100% of the e-discovery costs, 70% of the costs were focused on attorney review. So a goal is obviously in lowering e-discovery costs is to make the attorney time reduced, and spending a little more sometimes on the e-discovery technology or preparing your plan in terms of e-discovery technology is a great strategy for reducing your costs. So, obviously, if you can reduce the time spent on e-discovery review, you're going to cut your costs. If you can cut your costs in half, that reduces the overall cost 35%. So one of the things that we see is that, as e-discovery counsel, e-discovery attorneys, we'll see comparisons of that 30% of the budget, that e-discovery budget, which goes to looking at things like processing or the platform production. And there's no real consideration of the impact on the overall cost of review or the overall case. And, when you're considering budgets, I think considering how the impact considering what the impact is on the review is important. You can advance. So if you look at the overall e-discovery costs and attorney review costs in the context of the overall case value and legal costs, it gives you some context for looking at e-discovery costs. Legal costs must be considered in this, and I quote proposed new Federal Rule of Civil Procedure 26B1, which is an attempt, somewhat pro-defendant attempt that attempts to bring to the forefront proportionality in the consideration of e-discovery costing and e-discovery burden for defendants. So the new rule requires that proportionality be considered, the importance of the issues in the case be considered, the amount in controversy, the party's access to resources, and the importance of the discovery in resolving the issues, and whether the burden of the expense balanced against the benefit is appropriate. And I think that this will continue to put pressure on technology partners and lawyers to find ways to be cost-effective with these solutions.
Robert, before we leave the topic, let's talk about two myths about e-discovery. One is that it's a form of activity that only belongs in large cases, and secondly, that e-discovery is extraordinarily expensive. And what I'd like to do is start off with a small case and walk through with you some of the cost savings that can be achieved with electronic discovery done properly. We've had one of our clients tell us that they expect cases involving as few as 1,000 documents electronically because of the cost savings that are achieved thereby. So let's just talk quickly about a small case involving 1,000 documents. 1,000 documents typically would represent about 5,000 pages of material. If we were to print that out, it would cost us about $500, and at a review rate of 400 documents per day, it would take us about 2.5 days of attorney time to get through that material. That's the old-fashioned eyes on every document gold standard that was the practice as of the end of the 20th century. So if we look at that, we've got $500 for cost of getting the media available for review. And if we have a young associate at $200 an hour working for 8 hours a day for 2.5 days, we've got about $4,000 of review cost, or about $4,500 for our project. Now let's talk about what can be done with e-discovery, particularly with a ECA analysis done with metadata and extracted text with analytics. So what can Canon do, or what can another vendor in your position do in terms of giving us a a review and hosting for 1 month to complete that review.
Yeah, I mean, I think that there is a misconception out there that e-discovery on smaller cases is expensive and not cost effective. And, you know, for, you know, technology partners that are, you know, engaged in these smaller cases, especially where you can create business processes that simplify the process, you know, you're lowering your costs to, you know, a very low amount, and you're certainly lower than if you were to take the same equivalent of documents, let's say 3 boxes of paper, and copy it and go through and perform a linear review. So, you know, I think that as we see more volume in the smaller cases, specifically case teams or you know, groups of attorneys that have similar cases over and over again, you see those costs really dropping dramatically in terms of what the technology partners can do for that. And that's obviously one of the benefits of the SEEDS program has been the ability to create predictable repeat processes and pricing for specific types of cases.
So let's talk specific pricing. If we're talking the ECA mode, the cost we're currently being charged is $55 per gig. When we're talking about 1,000 documents, we're talking about 2/10 of a gig. So we're talking about $11 for processing, and the analytic cost is $21 per month, including hosting with this platform. So again, we've got 2/10 times $21. That comes out to about $4.20. And what's the licensing charge for the Canon product?
It's $35 per month per user. So it's you know, all in, you're at a very small price tag.
So in this case, if we look at the cost, we're looking at $50.20 to put it in the analytic mode. And with the first piece of the analytic mode would be just deduplication on MD5 hash values, so taking out the electronically identical documents. And that typically reduces our volume of data by about 40 to 60%. So let's pick the midpoint and call it 50%. We had that associate working at $200 an hour for 2.5 days. Now that individual is going to work for 1.25 days, or about 10 hours. We've dropped the cost from $4,000 to $2,000. So simply using the most basic rudimentary tool there, we've cut our cost from $4,500 on the old Eyes on Everything Gold standard to something on the order of $2,060.20. What can we do additionally with analytics like clustering and so on? What's your experience been in how the volume and the bulk coding can be done to further reduce the time spent?
Yeah, well, I think that you know, it goes to the point of the RAND study, or the point of reducing that 70%. We, and specifically with Lewis, obviously we've had a lot of success reducing through some of the technology analytics that we'll discuss later in the presentation, predictive coding, you know, grouping documents by similarities, or ranking documents by the existence of keywords. We're able to, you know, dramatically reduce that attorney review time and cost, and in some cases, you know, eliminate the need for attorney review altogether. You know, in cases where that makes sense.
So with that, we can probably talk about reducing the cost to about $1,000. So that's a savings of over 75, closer to 80% on the cost of review and processing. So that busts 2 myths: that e-discovery only works on large cases, and e-discovery is always expensive. Let's move on, Robert.
Okay, guys, that was great. I think that was a good example of you know, proving that some of those misconceptions about e-discovery are wrong. And let's kind of go back to, some of the e-discovery costs to make sure that we're all on the same page with what costs are involved in e-discovery. And I talked a little bit before about, the hard costs. These are the components that, have a high price ticket potential. And, these are just the costs that it costs to collect and process the electronically stored material for review and production. And, in terms of doing a budget, the nature of ESI kind of makes accurate budgeting difficult because you've got to make some underlying assumptions or guesstimates when you get started. But there's a number of different types of services in the market and services that Canon provides that we'll go over here that can help. You can apply different methodologies in each one of these categories to help reduce the 70% of the discovery cost that's related to the attorney review. So starting with professional services. Professional services include, people like project managers, discovery consultants, analysts, and technical people such as that, they cost less than your associates. And these experienced people can approach the processing phase from a litigation perspective, and they've also got extensive technical resources so that they can, meet capacity, scheduling requirements, and provide you with guidelines and recommendations for reducing the amount of documents that you end up doing a review with. The next category is software and hardware. And one of the key things there I think that we need to bring up is, law firms don't really need to be in the business of this. Not that you shouldn't have e-discovery expertise on staff and, tools to aid with case assessment and project management and so forth. But generally speaking, large investments in e-discovery technology and services is kind of a detour from a law firm's core business focus. They provide legal advice. And so I think that that's best kind of left to, competent vendors in the space because that's their core business is providing, not only the software and the hardware, but also the professional services that go along with that. And with, software and hardware, there's a couple different types out there. You've got, vendors who have a proprietary technology that they've developed themselves over the years that combines with their professional services in a way to give the best bang for your buck. And then you've also got vendors who provide a variety of tools they're technology agnostic and they provide a number of different review platforms. And then these softwares are generally provided in two sort of different ways. You can usually access your review platform via the cloud, and sometimes you can also get those solutions deployed on site in sort of a managed information technology solution. One of the benefits of working with a vendor that has proprietary technology is if you work with that vendor enough and you establish a good working relationship with them, with their management, with their CIO, their CTO, it puts you in a position to have discussions with them that, you can actually get features made or get things done with that technology that you might not have been able to do if you're working with a technology agnostic vendor. We've done some of that. Canon has done some of that type of business development and working together in collaboration with Lewis, specifically as part of the SEEDS program. Another example of cost categories is your document processing. That's the extraction of the text and metadata. Gordon mentioned that a minute ago, how inexpensive that can actually be. That's a thing that has to happen to get your data ready to search and review. And then he also mentioned the next category, the data hosting and access fees. That's typically charged on a per gigabyte and a user level. And then you've got your analytics, which is your...
Hey, let me stop you right there, Brad, because we have a question from the audience.
Let me, because you're about to talk about this anyway, we actually had a question from the audience come in talking about analytics and asking, what is this, who develops it, and doesn't the attorney have to be involved in its development for each case and each production? So Can you can you answer that question while you're talking about the analytics area?
Sure. Yeah. So first of all, analytics, that's a pretty broad term, and that could apply to things like technology-assisted review or predictive coding. It can apply to email threading, similarity grouping, concept searching, etc. And in terms of how it's used and deployed, an attorney does need to be involved in the deployment of that technology so that they take into account all the legal ramifications and their strategy for the case. But a project manager at the vendor can help that attorney, apply those business needs in the right way. Hopefully that kind of
on the analytics piece, Brad. On the analytics piece, I think it's important to remember that you want to try and find as broad a based set of analytics as possible, because one of the problems that often arises in an e-discovery case is the volume of data becomes very much greater than was originally anticipated. That can be a real budget buster. One of the things we want to talk about later is shifting on your use of analytics to keep the cost contained. If your data volume grows by 3 times, you're going to have to do something smart rather than simply continuing with the original analytic plan, particularly if you weren't using predictive coding. So yes, absolutely, the attorney needs to be involved, and the attorney involved needs to have familiarity with the various forms of analytic tools so that they can turn on a dime and employ different tools if the data volume and cost otherwise would go out of control. So knowledge and understanding of the analytics working hand in hand with your project manager is key to cost containment.
Right. And on a very basic level, when you are talking about using the word analytics, what we are basically talking about are the technology tools that you're going to use in order to analyze the data, the ESI. I mean, that is essentially what falls under the grouping of analytics.
I think that also it's important to point out that there has been a change in the way law firms approach this these technologies, and you see the emergence of e-discovery counsel, and Gordon is a good one to work with at Lewis. But I think the idea that there are e-discovery counsel out there that are knowledgeable about what these technologies can do generally, knowledgeable about what specifically their technology partners or chosen technology partners can do, and those folks can come in and assist taking the technology and choosing the technology and deploying it in a way that's defensible, because I think that the question probably comes from the thought of how do you sell this to a court, or how do you sell this to opposing counsel? And I think that's the value of what you can do when you're working consistently with a partner, a technology partner, is put that stamp of defensibility on the process, and really solve ultimately the legal problem, which is we're going to spend less time reviewing documents, but we feel more confident that we have the right answer and the right result.
Well, let's move quickly through attorney review and get to the next poll so that we can focus our second half hour on these cost savings techniques of most interest to our audience. Robert.
Okay, well, the last category I guess I was going to touch on there briefly, Gordon, was attorney review. That's another, as we know from the RAND survey, that's 70% of the cost of discovery. And in addition to applying all these techniques to reduce your document set that goes to review, when you finally get to review, there's other things that you can do there to reduce the cost by using an outsourced review solution, and that can range anywhere from $25 an hour up to $150 an hour, which is still typically less than what you're going to be paying your associates.
Let's move on then to the poll.
Okay, this is Ken back in. If you want to advance to the next slide. Before we get to the poll, which we will in 1 second, we're just going to shift our focus to Ediscovery Cost Containment now. This really is our core subject for today. And we've developed a number of these strategies with Louis Brisbois. Today, we'd like to focus on these 4: investing in information governance initiatives, applying the right model, using technology and analytics, and managing Ediscovery project budgets. But I do want to say that while we plan to address these 4, we do have many other strategies, and we do plan to address those in future webinars. So for now, before diving into our core subject, we'd like you to take a minute to answer the poll question: which of the following Ediscovery cost containment strategies are you or your clients most interested in? So if you could choose one: cost savings through A, client investments in information governance initiatives; B, choosing the right Ediscovery cost model; using analytics and technology to reduce review time; or D, smart management of Ediscovery budgets and vendor invoicing. So if you could take a few seconds to answer that, we'll be interested to see what kind of results we have. So we're getting some interesting results. We'll give it another few seconds before we put up the results. Okay, so we've got 8% that clicked on client investment in information governance initiatives as the topic they're most interested in. 38% choosing the right Ediscovery cost model. The highest number picked C, using analytics and technology to reduce review time. And close behind that was D, smart management of Ediscovery budgets and vendor invoicing. So I would ask our panelists any surprises or comments you would have on the quick poll.
No surprises there, Ken, but I think in defense of information governance, it should be remembered that the safe harbors under 36G or 37G of the federal rules and each of the states that have addressed e-discovery are entirely dependent upon the existence of an information governance structure. In other words, if your loss of data, which will occur in just about every case, is the result of the routine operation of an automated system, you have the safe harbor. Anytime you have a client who does not have a good information governance program, counsel has to be concerned about getting in early with a triage solution so that loss during the course of the litigation doesn't result in sanctions against the client, sanctions against the attorney, because after Zubilake cases, both the attorney and the client are jointly and severally responsible for preserving data, and also for those in the risk management world out there, carriers in particular may be responsible for providing a duty to defend, which includes presentation of competent counsel who avoid those sanctions. So information governance, while seemingly outside of the litigation sphere, is in fact ultimately an integral part, and good data management, we will see, shrinks the amount of data that will be retained and therefore has to be searched. So when you look at it that way, information governance is the base upon which the pillar of e-discovery is built. With that, let's move forward.
Great, thanks for those insights, Gordon. So if we go to the next slide, Robert, I think you want to take it and talk a little bit about investing in information governance initiatives.
Yeah, thanks, Ken. I'm just going to touch on this because of the poll results, but the bottom line is good information governance is obviously a very hot topic right now. Good information governance impacts e-discovery costs very simply, and that's decreasing the size and complexity of your data footprint is obviously going to decrease the amount of data that needs to be discovered and the complexity of what your lawyers have to do with it. And obviously, it's costs much less to deal with the issues you see on your screen inside your corporate client than it does have your lawyers sorting that out in the discovery process. And at Canon, we've got an information governance group of technologists that sort of systematically help come on site and help clients deal with these issues. And I had them kind of put together this overview of what we see out there. And we don't need to go into it in detail, but there are a number of things that can be done to sort of reduce that data footprint and complexity. Let's move forward.
Okay, so let's talk about choosing the right pricing model. There's a couple of different generalized pricing models out there, I think, in the market. One thing I would just put out there for everyone is that if you're responsible for purchasing discovery or really anything, it's not always a good idea to just jump at the cheapest or the first vendor. Sometimes it might make sense to use a more expensive technology because you end up using some of those analytics or something up front to reduce your costs later on. So it's important to kind of do your research before you pick what you're going to do. And so it's important, to kind of know what the different options are out there. So we talked about some of the cost categories before, and some of the ways that you can purchase those services are like through a processing model, where it's basically a per-click model or per gigabyte model for pricing, and you'll see that applied in two general ways. You've got a process all pricing, where the idea is you're just extracting all the text and metadata from all of the ESI that you're including in that matter for a set gigabyte price. And then you've also got another model called ECA pricing, where you're bringing in, this is a pretty useful price model when you don't know quite how much you're going to be sending to review at all. You haven't done a good targeted collection. So you can bring it in into the platform at a much lower rate, apply analytics and do your calling and your data reduction within the platform, and then produce a much smaller set to your attorneys for review. And then another type of model is that all-in pricing model, where we take, you'll see those cost categories that we talked about before, from professional services through processing, hosting, etc. And the vendor can bundle that all in to one set price for, per gigabyte, or a set price for the project, or even a set price for the custodian. When you go down that road, it's important that you've got some pretty good information about, the size of your case and the scope of your case, the number of documents, etc., to kind of work with that vendor to create that type of pricing. And then last, we've also got you'll see a multi-party pricing, cost-sharing type of a structure out there.
Before we leave this topic, Robert, you and I have recently worked on a situation where a client initially came forward with the basic unit pricing per gig for collection, for hosting, for processing, and so on. The number came out to about $125,000, and that assumed that we would continue to host all 200 gigabytes that were collected for the 18-month period. And client pushed back and said, wait a minute, that's an awfully big number for this case. How were we able to get that number down to about $36,000?
Well, in that specific case, we had some good information. As Brad mentioned, we had good knowledge about the size of the ultimate data set. We also knew that we would be able to reduce the the ultimate data size through analytics, and which we now are doing, obviously. And I think that the key is when there's some predictability there for the client, both the technology partner and the client are on the same page. And that's how we were able to get the cost down is knowing something about the data sets and being confident in your attorneys and our technology's ability to work together to really reduce the data size.
And some of the technologies that were used is rather than processing the entire data, most of the analytic work was done with extracted text and metadata without the native files, which kept the volume of the data being analyzed down, which keeps the cost of the hosting down. And similarly, by compressing the review time, we were able to take the documents deemed not particularly interesting and take those to an offline or nearline storage environment. Because one of the things that you will find over the course of a case is that hosting in online status of data for which you have virtually no use is very expensive. The cost is going to be somewhere between $15 and $20 a gig per month, and about 90% of the data you collect is not going to be interesting enough to produce to the other side or be used in the case. So if you use the standard models that most vendors stick with of simply charging you $20 a month per gig for that which is stored, you're going to run a very large number, and that was shrunk in this case by storing only the 5 or 10% that was useful. And what we get is about a $90,000 savings over the course of 18 months. Let's move on. So Brad, we're talking about the traditional cost structure of e-discovery.
Sorry about that, guys. I had you on mute. Yeah, we talked about the pricing models a little bit before, and this slide just kind of illustrates the cost structure of an e-discovery project and also the reduction of data and some of the common costs. When you're collecting and preserving evidence, for example, you might be doing things like restoring backup tapes at $275 a tape, consulting time at $225 an hour, doing collections of hard drives, maybe $500 a custodian. Then you're doing the document processing that we talked about earlier, and that runs from about $200 to $400 a gigabyte sometimes. And in that process, you're also doing that deduplication and removal of system files, I think that Gordon mentioned earlier. And then you get to the review phase where you're doing the hosting that Gordon was just talking about. That's ranging from $10 to $50 a gig per month. So it's important to only host what you really need for that case. And as Gordon was mentioning, that host only the extracted text and don't host the native files. And then in that phase, you've also got some professional services helping you along. Project management ranges between $75 and $150 an hour. And then we talked a little bit about legal review fees. If you outsource that, you'll be paying somewhere between $25 and $150 an hour. On the low end, that's going to be for people offshore, let's say in India, doing a first pass review. And on the high end, that would be, say, somebody who is a foreign language speaker when you have a multinational case. And then finally, we have, doing your production, which requires usually converting the native files to TIFF images at the rate of about 4 cents, maybe 6 cents a page, or you might be printing things for a penny to 4 cents a page and making load files and or doing a native file production. The other model that we talked about is the ECA model. Next slide. And the ECA model has the same cost structures that we just went over, but it has that additional component of bringing all of the data in at a much lower price, applying those analytics, and then getting into your processing and your review. And that you'll see that early case assessment ingestion rate being more around $45 to $55 a gigabyte instead of the $200 to $400 for processing. So you go through that phase, and that gives you a way to apply technology defensibility in a defensible way to really reduce your document set.
And I would just
move to multi-party use of a single vendor.
Gordon, if you don't mind, I'd just like to add on to what you said earlier. What I think, most of the hosting costs, or most of the costs in e-discovery on larger cases go to that hosting. And if you're working with a technology partner who, is, or a law firm that's not kind of actively managing that data that you don't need, sort of making a decision at some point and getting buy-in to that decision to eliminate the data that you don't need, I think is a very important cost containment strategy, if not one of the most important, because you eliminate that sort of ongoing cost going forward. So I think it's very important when you use the ECA model or you use some of these models and you get to the point where you've got your set amount of data, you got to remember to move the data that's out there to nearline storage or take that offline. You can always go back and get it. You don't necessarily have to set it up as a question, as a choice of deletion versus keeping it. You can lower the cost of that, and that that ultimately lowers your cost.
Yeah, that would have been a $72,000 component of that $125,000 number we talked about earlier. Let's move quickly through multi-party solution. Yep.
So,
Robert?
Yep, multi-party solutions. This slide represents the e-discovery information flow and costs associated with a multi-party case, and obviously there are a lot of litigation support costs and there are a lot of legal costs associated with the inefficiencies of having multiple document repositories. And when we were talking earlier about the structure of e-discovery costs and their impact on the overall legal spend, this is a great slide to illustrate that interaction. And if you think about it, when there's 5 parties, there's duplicate documents in each of their data sets. Every time data is produced, it's got to move back and forth between the parties, and you ultimately have 5 times the e-discovery cost. So, advance. So in models where you have multiple parties, if you can get agreement, and getting agreement is usually the most challenging part. But if you have e-discovery counsel and are willing to take the time to educate all the parties, there's usually a lot of positives to collaborating on a repository. And what that does is it makes it so that you have one spot for the documents. Our repository is called Case Data, Canon's e-discovery repository. And what that does is it makes it so the documents all live in a centralized environment, and then each party has specific access to the documents that they need. And what this does is it brings questions like, what do we do with duplicate documents? What is the set that we're going to house and call the documents for a specific party's deposition? All the exhibits can be tracked centrally. And in general, it just makes it easier for the parties to communicate. If you think about how many times when you're communicating either with opposing counsel or in trial, there's questions about duplicate documents or documents having the same document having 2 different base numbers, for example. That problem is greatly resolved with this type of model. So you want to move on to the e-discovery cost scenarios. This is an actual cost scenario that Lewis, Brisbois, and Canon put together for a recent multi-party litigation, and it just shows you how you can share in these costs. So ultimately, under a traditional model where each party was doing this themselves, the cost is multiplied, by 5. And if you can get agreement to share those costs, you might have some slightly higher e-discovery consulting costs up front to set up the model, but the efficiencies in terms of the billing model and in terms of the efficiencies of the document flow much outweigh those costs.
And the cost savings can be enormous. We had one a number of years ago involving 42 different parties in a architect and engineer construction defect case. 42 parties. The cost of using a single vendor lowered the e-discovery cost for each party to about 2.5% of what it would have been had they each gone out and retained their own technology vendor to provide support. So the collaboration is well worth the cost if you can get the court to make the appropriate case management order. Let's go on to analytics, Robert.
Brad, I think you were going to cover this. Go ahead.
Yeah, so we talked about analytics a little bit throughout the presentation so far, and a number of the demonstrated and most commonly accepted technologies for reducing the volumes are some of the ones that we see on the screen right now. We've got predictive coding, otherwise known as TAR, technology-assisted review, which is essentially machine learning. By working with a machine, a subject matter expert, an attorney who's familiar with the case can train the machine basically what documents are relevant and save a lot of time that way. There's email and other technologies to group documents together by concepts and relate them so that you can save time by batch coding them. Those things include email threading, similarity clustering, and then another use of technology for reducing your document set is keyword searching or document ranking. In fact, that might be an example that you might want to share, Gordon, about working with Canon, developing an algorithm for the case data platform as a result of a case need that you had.
Yeah, one of the concerns we have with keyword searching, which remains perhaps the most prevalent way of going about identifying documents, is there is no ranking of the documents of interest. They are simply jumbled and identified based on the presence or absence of a word on the list. So one of the things we went back to Canon with is say, we want to look at the more interesting documents first. So they developed an algorithm to serve up at the top of the list those documents which contain the largest number of keywords. And we're working along the lines of additional algorithms that will focus on the ratio of keywords to total words and the like, all of which are designed to push to the top of the list documents that are likely to be more interesting. So obviously, if a document has 15 keywords in it and it's only 1,000 words long, that's likely to be much more interesting than a document with 15 keywords that's 17,000 words long. So all those kinds of things can be developed with a technology vendor with whom you have a good relationship and an ability to identify what needs to be done. And that comes with having that long-term relationship.
And the last note I'll add there is just that, according to, some studies, that when you apply these different types of data analytics and you've got, someone with real expertise in the use of TAR or search methods, they've been shown to reduce data sets as much as 80%. So obviously that can have a huge impact on reducing the attorney review costs.
Then let's go to budgeting.
Yep. So the last kind of cost containment strategy that is recommended is common sense, but it's not always something adhered to when you're in the throes of a large case or an intensive case, and that's actively monitoring your budgets on cases, or the invoices and the process with your technology partners. So what you want to do, especially upfront, is require your partners to provide you with cost modeling. And we just showed you one that we worked on for the multi-party litigation. And I think what's important is you want to be able to create cost models that you can manipulate in an Excel spreadsheet or in some other type of model, so that you can see what happens when the data size triples, or you can see what happens when your anticipated relevancy of 20% jumps up, your keywords are bringing back 50% of documents, and see how that affects your case modeling and your pricing. And we looked at building in callers around, what happens when that situation happens, and you want to ask your vendors about that. And then routinely request budgets and as the case goes on during the first, let's say after the first month or after the first 3 months, to continue to make sure that you're on track. We see writing in written approval for certain services or certain caps is a good way to manage not only our internal teams, but our clients' expectations. And then I think the most important thing with the SEEDS program, manage that ongoing relationship, and come back and look at the end of the year over time, several projects, and say, how is what we're doing, how can it be improved? And we've been continuing to hone as part of the SEEDS program, and we do that with other clients where we're looking for improvements in that partnership to help all parties sort of be in a win-win situation.
And one final thought, Robert, is changing the focus of the budget. Typically, e-discovery budgets are put together on a unit basis, thinking we have 200 gigabytes to collect. That's going to cost X dollars to process and host. I think what we have to do in many cases, particularly for smaller cases, is develop kind of the reverse approach, figure out how much is in controversy, how much money can be spent on legal spend for the entire case, and then figure out what percentage of that legal spend should be devoted to e-discovery. It's going to be somewhere between 30 and 50%, and that becomes the upper bound of the budget, and it then becomes the task of the technologists and the attorneys to identify the analytics and the tools to get the project done within that budget, which is determined by the size of the case, the importance of the issues, rather than the volume of the data. Because if we let the volume of the data dictate what we spend, we're going to increasingly spend larger and larger amounts of money, because data volume is growing at about 80% per year, which means our cost, if we let data be the determinant of what we spend, will grow at a rate of 80% per year. So that's the takeaway that we all should be focusing on. And with that, I'll turn it over to Frank to wrap up.
Thank you, Gordon, and thank you to Robert and Brad and to Ken for all that information. I just want to remind you, we will be sending you a copy of the recording. That recording will also come with a copy of the slides for today, because as I'm sure you understand, there's some really key pieces of information that you all can use as reference, use to remind you, especially some of those cost models that I think will be very helpful. So we will send you that. Thank you very much for joining us today, and we look forward to your participation in a future e-discovery webinar through SEEDS. Thank you very much, and have a great day.